All right, I think we are live. So good evening, everybody. My name is Jonathan Zackerson, for those who don't know me. Sharon and Scott and Eric, if you guys want to go ahead and introduce yourselves as well. Start with Sharon.
I'm Sharon. I'm the founder of Let Them Breathe, and this has been quite a ride with Jonathan on this lawsuit.
That's Scott.
And my name's Scott Davison, also the legal advisor for Let Them Breathe, and working with Sharon, Neri, and Jonathan on all this crazy school reopening stuff, and working on this one now too. So yep, one of the attorneys on the case along with Ari.
Awesome.
And I'm Ari Spengler. I'm one of the attorneys on the case. In addition to Lee Andelin, who's not here tonight, but I work with him.
Yes, thank you for being able to come here tonight. So tonight we're going to talk about the hearing that we just had today regarding our lawsuit with Let Them Breathe and Reopen California Schools against the state, in particular over their school guidelines on quarantines, testing, and masking. So we had a court hearing today, temporary restraining order hearing is what it was. And so Ari, just kind of want to talk about maybe what happened, what it was today, what happened. We do have a future court date, and just maybe summarize that for us.
Sure. Yeah. So today we went into court. We asked for a temporary restraining order, which is basically you have to show that there's an imminent emergency. Something so urgent that harm will be done immediately if the court doesn't step in and say, stop doing this. So we were asking on behalf of all of the children in California for an order from the court saying the state has to stop enforcing mask mandates and quarantines and testing protocols. The judge found that since schools are open, and yes, kids definitely have a fundamental right to being in school and an education, she found that there was not an emergency because I think she saw that, yes, the mask mandates are a burden on education and a burden on our kids, but they're only really severely affecting a few kids, not all the kids in California. And the majority of the kids in California are attending school. So she, I think it's a really positive thing actually that she went ahead and set a hearing on a preliminary injunction for November 8th. And at that time, we're going to ask the court again to issue an injunction it's a longer term order, and it's also a more in-depth look at all of the evidence that the judge will have to do. So I'm pretty confident that we're going to go in very strongly and prevail on that.
So then,
Jonathan, can I jump in for any parents that are freaking out right now? Because I have a feeling there might be a couple parents panicking. I just want to clarify, it was very, very short. There weren't even any arguments made. So it's not like we presented all of our evidence and our expert declarations and we went back and forth and the judge decided, kids just aren't being harmed enough, and so we're not going to give you the emergency order. The state was trying to delay until March of next year, and this was a very short talk about timing, really. So everything Ari said is totally right. I just know that a lot of parents in their minds thought today was going to be the full hearing, and they're thinking, oh my goodness, the judge heard everything and she doesn't think these masks are harming our kids. And it was really just very brief about the timing. And then that's all I wanted to throw in there, just in case any parents were panicking.
Yeah, well, and I will add too, the state did file 1,600 pages of documents at around 11:30 last night. So there was no possible way that any of us could have read that and responded to it and digested it in time for the hearing today. So I think, the judge wanted time. If she's gonna make this ruling that has statewide impact, she needs time to do it.
So on that, let me ask you about that on the 1,600 pages that the state dropped, almost at midnight last night. It obviously is a stall tactic. How common is that? Is that what, often do they do this to delay, or is this something that's pretty abnormal?
It's a fairly common defense tactic. Yeah.
Yeah, I think it's
Especially
They did delay on our school reopening lawsuit.
right. That's
I
what I
mean,
was gonna say.
They
Like
did, yeah.
they actually pulled this stunt like in a different way with the school reopening lawsuit. So we kind of expected that they were going to try it. It's just that with the school reopening lawsuit, they just claimed that they didn't have enough time, to prepare. And so then this time they kind of went a different direction and just kind of did a data dump, right? And just said, here's, all these, thousands of pages of documents that go along with our opposition to this TRO. And so, they knew that there's no way we'd be able to do it. And if the judge did decide to have a hearing today and really go into the substance of the arguments, it would have looked bad, that it would have been obvious that none of us had really looked at the state's opposition, right? So then they could have run to an appellate court and said, oh, clearly we didn't get a fair shake. Nobody could have read all this stuff in 5 hours overnight. And so we just obviously want this all stayed on appeal, right? So it would have looked bad. We kind of, knew that that's what their tactic would probably be. They changed it up a little bit. And I think, the one thing that we were, maybe a little bit more concerned about was this, demurrer that we were talking about a few minutes ago, that they tried to basically dismiss all of our claims, that they felt that all of our causes of action are defective, and they were trying to get the judge to, basically throw them all out. But they also wanted to delay even having that discussion until March. And so that's what, Sharon, or, I think Ari was kind of mentioning too, is they actually didn't want to have this argument at all. Like, they didn't want to have a discussion about the substance of the issues. They wanted to just have a hearing on whether or not we should even be able to have this lawsuit go forward. And they didn't want to have that discussion until March of next year. So the good thing is the judge, knew better and saw through that and agreed that, we should be able to have that discussion, sooner rather than later. And that, we can have that discussion at the same time we have the discussion on whether or not an injunction is necessary. So that'll be part of the next hearing in November, as we'll be able to kind of brief all of those issues and have a substantive discussion of the issues and a legal discussion of the issues at the same time.
Yeah, so the other really good news is that if the state had a great case to make, then why wouldn't they have just argued it as soon as possible? Obviously, they weren't trying to delay just a few days. They were trying to delay into next year. And so if they have 1,600 pages, I'm assuming that 1,600 pages isn't really filled with much that's solid, or they would have wanted to just, go ahead and argue it sometime soon. But what our legal team did, to get us a hearing November 8th, when they're trying to get this entire thing dismissed and only talk about wait till March and then try to just get the whole thing dismissed. It just shows, how great the legal team is that we're working with, and that everybody's been so generous to help fund this lawsuit. And so a lot of positives coming out of today. And I just want parents to focus on that, because I know they're suffering, they're concerned, and they want this to happen quickly.
And that's why we started, in the summer, because these things do take a long time. If we would have waited until now to do something, we wouldn't be, in this position where we want to be in November into March, essentially. Yeah. So it's just good that we got started. And I would say I'm counting there. We had 3 really big wins, and maybe the one area that we wish we would have gotten that last piece would have obviously winning the temporary restraining order. So in baseball terms, I say we got a triple, and we were shooting for a home run. So I think that's pretty good. And
the demure, am I saying it correctly, guys? That in layman's terms, the way the attorneys explained it to me is that the reason they were arguing that we don't have any grounds to stand on is because they're the state, there's an emergency order, so they get to do whatever they want. This is layman's terms. This is not how it sounded in the legal argument, but this was how it explained to me. And that just proves the point of why this lawsuit is so crucial. Because if the state thinks they can just do what they want, if there's a health crisis, an emergency that's been proclaimed, and parents can't even bring a lawsuit with attorneys that and expert witnesses that know the science and know the law and want to have that legal conversation, that's exactly what we're saying. The government is just expanding their power, and they don't think that they have to answer to us or even have a discussion with us. And so I think that argument, although it's really concerning, was good to hear in that it just validated how important this is and how important every single person involved in bringing this forward is.
Yes. So November 8th, we have the preliminary injunction. So can you kind of talk a little bit, what does that mean and what do we expect to come out of that hearing on November 8th?
Well, that's the main hearing. The way that we brought this lawsuit allows us to go in early, basically, for an early trial before doing a bunch of work and discovery and waiting for, sometimes trials can be 2 years out. So this mechanism gives us a way to get in before the judge and to present the evidence and to ask her at that time to issue an order saying, stop doing what you're doing to the state. So at that point, we're going to ask again for the judge to issue an order directing the state to stop enforcing the mask mandate and allowing parental choice. And we're also, we're also asking for the state to stop enforcing the quarantine and the testing. But in their opposition, the state actually has admitted that those are just recommendations and they don't expect schools to actually enforce them if they don't want to.
Yes,
so that was the bombshell right there. If anybody,
that was bombshell, exactly. I think that's huge. Yeah. So we're going to touch on that. They're going to touch on that just in a little bit here on that. Anything else that we need to maybe share about what happens on November 8th? Or do you think that covers it? That's the next big court date. We hope, that's you said, that's an actual hearing that we're going to have beyond the emergency hearing. So emergency hearing is like there's an imminent threat. You have to stop it immediately. Right. So that's what that one is. And November 8th was the soonest she had available, right? Is that what she said?
It
right?
was, yes.
Yeah.
And, I think it's a really good thing that she actually set the hearing for this preliminary injunction, because a judge doesn't have to do that. They can say, you haven't demonstrated that there's any reason that I should even consider this. So I'm just, denying your request, and we're going to set this matter for trial in a year and a half.
And the other thing that I really appreciate that she did, she said it for, basically like right after lunch, and said that the whole afternoon is going to be set aside, and that she expects these to be extensive arguments and a lot of evidence presented. And then she even did a little bit of talking with both sides, just kind of presenting her requests for how to get certain things to her and share that evidence and such. So that everybody could really understand it and have a good conversation. And so I really appreciated that. I thought it was a fair conversation. And, definitely, like all of those wins, we need to make sure that the parents understand that this wasn't, we did not lose the lawsuit today. This was a whole lot of wins today.
Yeah, it was a triple. It was a triple. We went for the home
There we
run.
go. We'll get that home run.
Yeah. So we'll score on November 8th.
There we go.
All right. So mark your calendars, November 8th, 1:30, right?
Right.
Yeah.
Right. Awesome. So let's talk about this bombshell and a couple other things. So last night the state dumped 1,600 pages, and in this document they submitted something. It was a response to the opposition response, right? And in here they made, in a section, one of their arguments was, again, this was specifically against the quarantines and testing, is they made an argument of why we don't, we shouldn't, it doesn't matter, right? Why we can't see that. So could you talk a little bit, or, Ari or Scott, talk a little bit about that?
Scott, do you want to handle that one?
Yeah. That's this is my pet project, with Jonathan and some others, is that I'm as much as I hate the masks, I really think the most harmful policy that the state has created is the quarantine issue, which is related to the testing issue, right? Is like, if you get quarantined for being in close contact, you can come back once you test, or if you get, come down with cold symptoms, you're kicked out of school for several days until you go get a test. And so, to me, like, when somebody, said, a month or so ago, like when we started to notice like how bad this is going to be, it's like quarantines are the new school closures. Is that basically these quarantines are going to be just as bad as school closures were last year, because, we're going to be selectively kicking students out of class for, weeks at a time. You could continuously get kicked out of class. You can get kicked out for 2 weeks and have to quarantine. You can come right back, and then the very next day get quarantined again, right? And every time your child has a stomach ache, or, you know, just a headache, like they'll send you home, right? And so to me, like those issues, those quarantine issues are devastating. And we saw, you know, that some of these school districts at the beginning of the school year were quarantining thousands of kids. You know, Glendale, you know, for example, was doing that. And so, you know, we were trying to work on that from the beginning. And what we noticed is that the CDPH guidance, it really just said that these were recommendations, right? And that, oh, well, you know, these are the recommendations for quarantine protocols. But the school districts weren't interpreting it that way. And even the county health departments weren't interpreting that way. They all thought everything on this list is required and we have to do all of it. And so, you know, we were trying to push back with some of our school districts and some of our county health departments and kind of say, hey, look, we don't think that you really have to do any of these really restrictive quarantines. And, you know, we have data showing that these quarantines aren't effective, that none of these kids end up testing positive. The rate is incredibly low. And so we ended up having to make a legal argument to that effect, because even though we believed it wasn't a requirement and we thought the state agreed, we just couldn't get anybody to say that on the record, right? And so we ended up making that argument in our, you know, TRO request to force the issue and just say, hey, you know, state of California, is this required or not? And so that was the one thing we found, you know, kind of buried in the middle of their opposition last night, is they had an argument in there where they just explicitly said that, you know, quarantine and testing protocols are simply recommendations. You know, they put it in italics, and that they are not required. And then they even went further and said, you know, that they actually, you know, according to the expert declarations that they have from county health departments and, you know, directors, that, you know, they really think that this is a local issue, and that, you know, the county health departments should decide quarantine and testing protocols based on local conditions. And so that's even better, right? Because, you know, that's what they should be doing with masks, right? Is like all of these issues should be determined based on local conditions. And right now they're based on no conditions, and they should be based on local control instead of state control. And so that's from a legal standpoint, getting them to acknowledge that is huge, because now we can go back to all of these school districts and go back to these county health departments and say, here it is right in their answer. Here's the state saying, these are only recommendations. You don't have to abide by any of them. And so, you know, if we can present the evidence showing that quarantines are completely unnecessary, that they're not helpful, that they don't, keep kids from getting sick, because these kids aren't getting sick when they get quarantined, and showing how much harm they do, then I think that'll be a big step for us, you know, to kind of get back to normal. It's, you know, two big steps back to normal. We don't need to test, because you're going to get false positives too often if you don't have symptoms, and you really don't need to be quarantining these kids either.
Yes. So a couple things I want to mention, or, you know, expand upon the things you said here. So in this statement, we've posted it in our Facebook groups. We've posted on Twitter. You know, if some people are trying to find, hey, where can we get that admission? Is that they can go there to get it for some stuff?
Yeah, I mean, you know, we'll have to, all of those documents are public record. So, you know, it's too hard to, like, you know, download them from the courthouse website. Yeah,
it's very difficult. Yeah.
In their records. But we have all of those documents. So we'll post them, you know, Sharon posts most of those to the Let Them Breathe website. So eventually we can throw them up on there and have them as references.
Yeah. Yeah. But we'll have those references. Like I said, we have those screenshots from those sections.
Oh.
They also.
I'm muted, guys. I was trying to tell you where they are, and I. I'm so sorry. My kids were a little crazy, so I muted myself. So anyway, yes, we actually already have part of that up for everyone. So I popped the law. So if you go to letthembreathe.net and click the lawsuit tab, I'll also that link is in the comments right now. It has our entire complaint. And then if you scroll down, the last thing on the page right now is our press release that details about that. And I'm also going to put up a screenshot of where that is in their actual opposition filing. And then we are going to be hopefully early next week, if Scott, you know, doesn't have too busy of a weekend, we are going to be posting a whole separate page on letthembreathe.net, similar to our school advocacy page, but this will be on testing and quarantining. And so we will have an advocacy letter that you can send to your school board trustees or your private school director and say, here is the state acknowledging that these are just recommendations and that you do have local control in this matter, and we'll play nice first, right? And then and we've gotten a lot of school districts to adopt our mask choice resolution, to stand with us using this same method. And then we will also put out resources shortly after that for any school districts that are not, they're still being restrictive. They're trying to blame it on the state even after we've clarified. And that will be more of a cease and desist to say, what you're doing is harmful and you don't have anything to back it up because the state has said it's just a recommendation. So that's going to be going out there to parents. Will go to letthembreathe.net, click the join us button, our newsletter, and also our Instagram is and our Twitter. You'll hear right away when we have that ready. And for any tired mamas right now that have had a long day and they're just like sitting here with their tea or coffee, that's like, I don't get it. That was a lot of info. The easy way to break it down is we were suing over the masking, testing, and quarantine guidance. And it's basically like today, without even having to have a ruling, we won 2/3 of our lawsuit. This is still going to have to be addressed, but basically the state acknowledged that two of those, aspects of guidance are recommendations. And I've heard from so many school board trustees and directors that the guidance is so convoluted and the state has been so threatening to them that they're just going with it because maybe it is a requirement. They're being even more restrictive than it because they're scared of having punitive measures. So this is really huge. And we know that some media, some different people or, may try to minimize what happened today and say, oh, well, they didn't get the emergency order. No, we've got huge wins out of this, and we're going to have that preliminary injunction. Jonathan, like you said, that's a big deal, or maybe it was Ari, just to have that scheduled is really a win as well.
Yeah, so that's a good point. So let's see. I just wanted to mention, so there's a comment here talking about schools getting threatening letters for not following the guidance. Now, I don't know if schools got over the mask guidance, because we did see that when certain schools were saying, when that first came out, they're going to be optional, that CDPH came after and says you must enforce the mask requirements. So if that's not the case, Jenny, if it's more broad than just that, let me know, because this change, this admission in this filing from the state changes that. Now, in that same section, they do say the masking is a requirement. They just call out the quarantines and testing as being recommended, and that it's up to local conditions for those pieces. So if it's anything outside of the masks, and really there's only two things in the guidance that when I read it are specific requirements. That is the masking, and that schools must have a plan on how to enforce that at campus. And the other is notification of COVID positive cases on campus to local health and CDPH. So, and that's actually through, I believe, an AB 130, that's a requirement to notify the health departments, and maybe there's some other another aspect of code. So those are the only things that are very explicit as having to do. Everything else is a recommendation. So even in areas that are more that try to take this super cautious and follow, they're so worried about whatever it is, and they still want to follow the guidelines. If there's something in the guidelines that aren't working for your school, then you could tweak them, right? For example, this idea of quarantine, this is a big deal. Quarantining for maskless exposure. A lot of these schools adopted a outdoor mask mandate because they're so worried that they would have to quarantine kids for outdoor mask exposure. This gives them leniency and say, you know what, we don't have to even with the Q&A update that they had last week, where the CDPH says that transient, exposure at recess is not going to qualify for the 15 minutes, so don't even bother essentially contact tracing. That gives, I think, enough information for these schools to say, you know what, it's ridiculous. Let's not contact trace outside at school, outside at recess. We don't have to worry about any of that stuff. Kids can take their masks off outside, and they don't have to worry about the quarantines and even testing for that, because it doesn't even count. And you can modify your policy. Even in the most, overly cautious districts, you can still have that win. So, and I think that's—
I just threw, Jonathan, the person that was asking about, I just threw our students' rights page. So if you're asking about masking, the letter I just threw in here, you could send, if they're being, they're enforcing in harmful ways, you could send that to your school. And this is what we'll have for the testing and quarantine will probably be shorter than this letter, but it'll be similar to this. So that's something people can grab.
Yeah, and for those that are asking about getting that admission, we did take screenshots of this section of their filing. So in the meantime, before we get these other documents up, if you want, you can, go, obviously it's in our Facebook groups. You can go to our Twitter accounts. We each posted it today. So it's at Reopen CA Schools, and Let Them Breathe. It's at Let Them _breathe.
So Twitter is Let Them _breathe. Instagram is Let Them Breathe all underscores, but you can find everything at letthembreathe.net. And then of course we have the Facebook group.
Yeah. So I'm just talking about that screenshot. I'm talking about just that screenshot.
Oh, yes. That's on Twitter. And I loved what Scott said about how this also makes the fact that masking is the only thing, the big main thing that they're not allowing local control on even more ridiculous, because obviously there are some aspects of quarantine that can be effective, right? If a kid's sick, they shouldn't come to school. However, there's nothing about, I shouldn't say this on Facebook, but there's nothing about those things across your face that are effective. There just really aren't. It's such a small percentage of effectiveness, and then after 15 minutes, it's pretty much gone. And if the kid chews on their mask, it's gone even faster.
And their cloth.
Yeah, these cloth masks, it's just pure theater. They're not effective. And so why is that the thing that they don't even have local control over? Because most of our school districts would do the right thing if they had control. I think that's why they're holding on to, this paragraph.
And I want to mention a statistic as well. As much as I don't dislike what LA County and LAUSD have been doing regarding the mandatory testing, and the quarantining going on there, they took it a step further, prior to a couple, I think last week or 2 weeks ago. They had required all close contacts, within that 6 feet to quarantine at home. They actually made that a requirement. You didn't have a choice. They did change that because after 4 weeks of data, right, mind you, they test everybody. Every week, everybody has to get tested to go to school. They found that of those close contacts, right, so those people that were exposed, there was a known exposure at school, only 0.2% of those individuals contracted COVID. Now, mind you, that's probably in line with just if you were to randomly test the kids during that same time frame. So it's very possible that these quarantines not only did it not prevent maybe 0.2%, it may have not prevented anything. So that just tells you how disruptive it is to education and ineffective at stopping transmission. At school, at least at school campuses, from the data that we have. So as much as I'm upset, that's just incredible numbers from LA County, and there's no need at this point to quarantine healthy kids. Obviously, if you have a positive COVID test, you're sick,
that's where that kid should be quarantined, right?
Those people should stay home, right?
Stay home for a little while.
And obviously, contact tracing will probably still be around for people, so they can at least tell people, hey, you've been exposed to COVID. And you can then monitor and say, okay, do I have symptoms? And if you do develop symptoms, at that point, you would then quarantine yourself, isolate yourself and get a test. But most of the time, 99.8% of the time, it's not going to be COVID. And so, and even if you were to say those kids stay on campus, you multiply that 0.2% by another 0.2%. And I think we're looking at like 6 kids that have all of LAUSD would have gotten COVID from that, You're
speaking common sense, Jonathan.
I know, it's not allowed. So I don't know. So, again, I'm not going to really touch on I think some of the other stuff I've got really packed here. I don't know if there's any other questions that people have. I think we've addressed everything that we've seen so far. Let's go see here. Yeah, I do remember that sending kids home. Again, that was a mistake. That Santa Rosa so Jenny, I was talking about San Ramon, literally sending kids home, 60 kids because of misunderstanding. Does not have to apply. Again, the idea is, we have data, we know it makes sense, we don't have to do it. And that's an example that says, even if you're trying to follow state protocols, there's a situation that you can make an exception because it's not practical and it doesn't make any sense. So. If you guys have any questions here, go ahead and get them in now. I think we're going to be wrapping up here. Any final words as we see the questions come in, or anything else that people need to know regarding the lawsuit, or just regarding some of the advocacy happening? What lotto numbers to pick for this weekend, whatever.
Yeah, right. Well, talking about so there's a segue into not the same thing, but right, slight segue. We got to talk about money here just a little bit. I did throw the GoFundMe in there because we're so thankful. The only reason we've been able to get to this point is because of everyone's giving and sharing. If you can't give financially, then please share. That means a lot too. Our GoFundMe has really picked up steam and has kind of gone viral because people know that we are literally, fighting this mask mandate statewide. It's amazing. So, if you can forego a cup of coffee, or if you have more, please support, please share. And then, just for anybody that just feels like, oh man, even a few more weeks is going to be tough, just stay connected in our community, reach out, give somebody a hug, encourage each other. And if you are feeling like, what in the world do I do in the meantime? If, we are still open to, if there's anyone with a really specific, compelling story, please email that to smile@letthembreathe.net. There's a lot of kids suffering, but if you have something really specific, a hearing impaired kid, a English language learner, so a kid that has gone through extreme harassment or discrimination over not being able or to keep a mask on at school. If you're an educator, if you're a health expert, please email smile@letthembreathe.net, because you know what? If we have to wait, we might as well find a few more good declarations and evidence to submit in November as well.
Yeah, and maybe touch on that financial one tactic, and Scott, you could probably, you experience this more, but one tactic, right, the state might do is, with all these delay tactics and everything come up, they're going to try to drain the legal fund for some of these advocacy things. They're just hoping that they could just throw enough of this at you that you eventually run out of funds and you have to give up and you can't continue pursuing it, even though you'd win on the merits of it. So something that we're not going to do and not let happen is let us be outfunded, with the state's unlimited resources on this. And so, that's, I think, critical. And so if anyone in the state is watching, your tactic on that, you are going to lose. We will not be outfunded, period.
Yes, yes, we are standing strong. And that's why it's so great, that she was very fair, gave us that next hearing date. And, our legal team is amazing. They're in this for the kids. And so they really minimize, there's no like, oh, let's spend extra time on anything. This is really a focused effort, and people can know that when they're supporting, they're really, really making a difference.
And I'll say, kind of as my concluding remarks is, even though we're going to be waiting for this hearing, yeah, we have the opportunity to, file some revised pleadings and maybe go out and get, another expert or two. But the other thing that's going to happen is the state has promised that they're going to reevaluate masks by November 1st. And so, we think it's probably, a joke that they're not really going to do anything. But in theory, they claim they're going to, reevaluate all of these, kind of policies no later than November 1st. So at some point, before this hearing, they'll at least make some type of, pretend, announcement that they're going to, keep masks in place, for the rest of the fall, or possibly, maybe the best thing would be if they came up with like a metric and said, hey, we're going to come up with some metrics based on, hospitalizations and vaccination rates. And that's when, you'll be able to dial back these restrictions. We don't anticipate that happening because they've never given any hint. And in fact, they've given comments that are basically the opposite, indicating that they have no idea when we'll ever be able to take off the masks. But at some point, in the next, month or so, we're going to see something from them. And so, for everybody who's waiting around thinking there's nothing I can do right now, we need to keep advocating. We need to keep advocating to our local school boards and to our superintendents, and making sure that our stories are heard, and that if kids are suffering and having trouble with school, we need to make sure that their teachers know that, right? And we need to make sure that the teachers who are experiencing this, are reaching out to their school boards and superintendents. So we need to keep up the public pressure to kind of show, the damage and show how unnecessary these masks are and the damage that's being caused by them. And certainly we're going to have these campaigns with the quarantines and the testing too, but let's keep up the pressure. Let's not, take our foot off the pedal, just because we're going to have to wait a little bit, for the next hearing. Is we need to keep that pressure up and make sure that we keep visibility, and that people realize, like, at some point we're going to have to take off the masks, and we need to have that conversation, and so we need to get there.
And Scott, a good way to keep up that pressure is on letthembreathe.net. On the main page is our one-click campaign. I think, Jonathan, you have that linked in your Facebook as well. And it's a petition that actually works. It verifies that and goes to your representative. They know that it's verified that you're a constituent of theirs. And so that is a great way to keep the pressure on. And then also the funding is a good way, right? Because they can see that we can actually fund this, and then continuing to share, they can see our social media numbers. If they know that we are a large group that can actually carry this lawsuit out, if they revise on November 1st, I am going to 300% say that was because they knew we were going to beat them in court, and it was a way of saving face. I absolutely know that this lawsuit is putting pressure on them. Yeah,
I think just the pre-announcement of the lawsuit back in June, I believe, I think had influence over the state and how they set up the reopening guidance. Our advocacy, the whole process that we've been through has had influence, even if you don't necessarily get that direct win from a judge striking something down from the state. So, Harry, any last words? You good?
Yeah, I'm good.
Okay,
yeah. Sorry.
Yeah, I do see a couple of comments in here saying things like I think Jenny and Julianne, you're mentioning, things that you hear that don't seem quite right or seem odd here. So we have Julianne mentioning that it sounds like they're supposedly get some updates to quarantine protocols. Now, I don't know if it's coming from the state or from their local district, but if you hear stuff that you're curious about, you want to learn more, and it doesn't seem right, send me, especially when it comes around some of these crazy quarantine issues, send me an email, reopencaliforniaschools@gmail.com. You can message me on Facebook. One of the things that I think are helpful is if we come across these crazy stories is let's get this information out there, right? Let's make it known, because again, I think that's probably shaped some of the policy when people hear how ridiculous the application of the quarantines have been, right? Shutting down entire 6th grades, 20% of the campus has been in quarantine over the first 2 weeks of school, things like that. We need to get that information out there. And so if you have insight to anything that you're hearing locally or at the state level, we have a lot of people in this group, and crowdsourcing this has been one of our strengths. And so let's keep that up, and let's share that information, and let's get that information out there.
Can I throw in one other thing, Jonathan?
Yeah.
For any parents who are concerned about, I know we're a very diverse group with a lot of viewpoints, but any parents that are concerned about other mandates that are rolling out, I'm not going to say anything that'll get us in trouble, on Facebook. At letthembreathe.net, you can click the Let Them Choose button. It is a separate initiative, but you can check out what we're starting to look into doing there as well, if that's something that's really on your heart. If it's not, don't worry about it. It's really a separate initiative kind of born out of some of the Let Them Breathe community's concerns. So I just want to put that out there, because I know there are some parents that are really struggling through that right now.
Awesome. Thank you, everybody. And thank you, Scott, for answering that last question here. Yes, if the question was, can people petition their school districts to end the masks mandate? You could try, but there's some huge risks that the state has basically imposed, from insurance to the state coming down on them. Pretty much they said no, which is why, big reason why this lawsuit is necessary, and why we're suing the state and not individual school districts over this, because school districts don't have a choice in masks. So it's important to put the state first. Yep.
The main thing they can do in advocacy to their schools right now is, I just put the link up here, send our resolution. Scott just updated it to be in line with what the CDC had just revised, or CDP, I don't even know who revised something. Scott knows. He made sure it is legally sound. There you go. That's what you need to know. But we still are hearing, every week, different school districts passing this resolution. And that is a really huge way to put pressure on the state, because it's an entire school district saying, we stand with Let Them Breathe. We want mask choice, and we don't think your decision is wrong to the state. So that's a really, really key way to advocate. And that's kind of the strongest stance they can take. The other thing that school districts can do is not enforce in a way that would violate kids' rights. And so that's the part when the students' rights link that I put up there, that letter can put school districts that are bad actors on notice, and then it can support schools that want to do the right thing by saying, look, you can't drag a kid out of the classroom. You can't kick them out of in-person learning because here are their rights, even if the state is threatening you. So those are a couple things you can do in the meantime.
Yep. And if you are late to watching this, so you're done from the live, and go ahead, and if you have a question too, go ahead and ask it in the comments, tag one of us, and we'll go ahead and we'll try to answer it after the fact in here to get all that information. Share this video. Share this video with obviously in all the reopen groups. Share this video with your school board administrators, right? Your school board administrators and so forth, right? Let them know that there's options out there, and that there's the fight continues. So, yep. All right, Ari, Scott, Sharon, thank you so much. Everyone, enjoy your evening.
Thank you.